Veuillez vous asseoir. L'audience reprend et j'invite Monsieur le professeur Touvenant de continuer son discours.
Merci beaucoup, Monsieur le Président. Monsieur le Président, Mesdames et Messieurs de la Cour, je parlais avant la pause de la rigueur avec laquelle il sied de vérifier l'existence d'un engagement conventionnel. C'est avec cette rigueur qu'il convient d'évaluer la portée juridique des accords informels, déclarations ou communiqués, lesquels ont en principe vocation, comme l'indiquait le professeur Jacquet dans son cours donné à l'Académie de droit international de La Haye, à, je cite, « ne donner naissance qu'à un modèle de comportement de nature politique ». Fin de citation. Ce n'est que dans des cas exceptionnels, écrit-il encore, que ces instruments pourront créer des obligations réciproques, de sorte qu'il faut être, je le cite, « prudent lorsque l'on se livre à l'analyse d'un engagement pris dans un tel document, car il pourrait s'agir d'un engagement purement politique ». Fin de citation. Un bel exemple d'engagement sans portée juridique obligatoire, exprimé dans un communiqué, a été donné dans l'affaire du plateau continental de la mer Égée, dont la Bolivie fait curieusement grand cas. Dans cette affaire, la Cour a considéré que la question de savoir si le communiqué conjoint de Bruxelles du 31 mai 1975 était un accord autorisant la saisine unilatérale de la Cour dépendait, je cite, essentiellement de la nature de l'acte ou de la transaction dont il était fait état, fin de citation, et qu'il fallait, je cite, tenir compte avant tout des termes employés et des circonstances dans lesquelles le communiqué avait été élaboré. Fin de citation. La Cour a conclu dans cette affaire à l'absence d'accord juridique, après avoir exploré les circonstances et les termes du communiqué, dans le texte duquel les premiers ministres concernés avaient pourtant utilisé le terme « décider ». On le voit, et c'est bien normal, Monsieur le Président, car les souverainetés ne sauraient se lier par inadvertance. Pour qu'un communiqué conjoint puisse être considéré comme un accord juridiquement contraignant, ce sont à la fois ces termes et les circonstances dans lesquelles il a été rédigé qui doivent y concourir. Si les termes n'y sont pas, les circonstances n'y suffiront jamais. Si les termes y sont, mais pas les circonstances, aucun accord ne sera caractérisé. J'en viens alors au cas d'espèce. Monsieur le Président, permettez-moi d'ouvrir une parenthèse purement linguistique. La phrase, en anglais, « is open formally to enter into a direct negotiation aimed at searching for a formula », fin de citation, ne signifie pas, comme le soutient la Bolivie, disposer à entamer officiellement des négociations directes en vue de trouver la formule, mais signifie, ce qui est tout à fait différent, et disposer à entamer formellement une négociation destinée à chercher une formule. Ceci précisé, j'observe que les textes dont la Bolivie prétend à tort qu'ils sont des accords explicites indiquent du Chili qu'il est, en anglais, open to enter into a negotiation, selon la Bolivie, willing to enter into a negotiation, ou resolved to continue the dialogue avec son voisin. Ces mots reflètent-ils ordinairement un engagement juridique? La réponse est négative. Permettez-moi, Monsieur le Président, de l'illustrer brièvement en évoquant 3 cas typiques récents dans lesquels les mêmes mots que ceux que la Bolivie met dans la bouche du Chili ont été utilisés par des États sans aucunement signifier une intention de s'obliger juridiquement. En septembre 2013, alors que l'Iran était mis en cause à raison de son attitude à l'égard de l'arme nucléaire, le président des États-Unis, Barack Obama, fit savoir par ses services de presse que, je cite, « It had long been the position of President Obama that he'd be willing to enter bilateral negotiations with Iran. The extended hand has been there from the moment the president was sworn into office. » Fin de citation. L'année dernière, l'ambassadeur de Chine au Mexique a rendu public que, je cite, « China is willing to negotiate a free trade agreement with Mexico. » Fin de citation. À l'évidence, mesdames et messieurs de la Cour, aucune de ces déclarations unilatérales n'a eu pour objet ou pour effet de créer une obligation juridique. Derrière ces mots s'expriment des postures politiques importantes, sans doute, sur le plan politique et diplomatique, mais pas des engagements juridiques. Quant aux déclarations conjointes par lesquelles les États se disent « resolved to », résolus à telle ou telle action, là encore, la pratique démontre sans appel qu'elles n'ont pas vocation à créer des obligations juridiques. Parmi bien d'autres, le communiqué conjoint des ministres des Affaires étrangères du Japon, des États-Unis et de l'Australie du 25 juillet 2016 en est un bon exemple. Il indique, entre autres, que, je cite, « The ministers resolved to further strengthen cooperation in the following fields: effective implementation of the Paris Agreement, striving for entry into force in 2016. » Fin de citation. C'est peut-être dommage pour l'accord de Paris, mais il n'y a évidemment derrière ces mots aucune obligation juridique. Conclut ce point, Monsieur le Président, les mots dont la Bolivie assène qu'ils sont porteurs d'obligations juridiques n'ont pas cette vocation. Au titre de son bouquet de thèses alternatives, la Bolivie en appelle aussi à l'accord tacite et à l'acquiescement, comme si les théories de l'accord tacite et de l'acquiescement étaient des prix de consolation pour celui qui échoue à prouver un accord explicite. À l'évidence, la théorie des accords tacites ne peut se manier qu'avec d'extrêmes précautions. Ce n'est que lorsque la preuve de l'existence d'un tel accord est solide comme le roc qu'elle trouve à s'appliquer. Or, et par un contraste assez saisissant, le propos de la Bolivie sur l'accord tacite et sur l'acquiescement d'ailleurs est singulièrement peu articulé. Dans ses écritures, la Bolivie en appelle à une déclaration politique faite dans le cadre de l'Organisation des États américains le 26 octobre 1979, à laquelle le Chili aurait opposé un silence que la Bolivie prétend approbateur. Mais, Monsieur le Président, les diplomates savent bien qu'ils n'ont aucune obligation de répondre à tout ce que disent leurs homologues devant les organes politiques des organisations internationales. La Bolivie s'est également référée, y compris cette semaine, à sa déclaration de novembre 1984, faite à l'occasion de sa signature de la Convention des Nations Unies sur le droit de la mer. Mais il suffit de la lire pour comprendre qu'elle n'appelait aucune réponse du Chili, puisqu'elle se bornait à faire valoir l'aspiration bolivienne, sans aucunement prétendre que le Chili serait juridiquement tenu de négocier afin de la satisfaire. Pour le reste, mardi dernier, le professeur Acavant s'est borné d'abord à tenter, en vain, je crois, de vous convaincre de ne pas aborder la question des accords tacites avec la rigueur et l'exigence qui vous caractérisent et sont reflétées dans votre jurisprudence. Ensuite, à arguer que le fait que le Chili ait clairement et distinctement fait valoir à plusieurs reprises que rien dans sa conduite ne saurait être vu comme l'engageant juridiquement, confirme le contraire, parce que l'exception confirmerait la règle. La Cour appréciera. J'en viens à l'acte unilatéral sans redire l'évidence, sur laquelle d'ailleurs les parties s'accordent, qu'un tel acte ne peut créer d'obligation juridique que si telle est l'intention clairement affirmée de son auteur, et si une telle intention résulte incontestablement des termes de l'acte comme des circonstances de son adoption. Je n'insiste pas non plus sur la rareté des actes unilatéraux créateurs d'obligations juridiques, laquelle rareté s'explique facilement, étant donné qu'aucun État ne se prête de bon gré à faire des concessions spontanées et gratuites. Les parties s'opposent ici sur au moins 3 points. Premièrement, contrairement à ce que suggère la Bolivie, ce n'est pas à la légère qu'un État peut prétendre qu'un autre a unilatéralement tenu des propos qui l'engagent juridiquement. L'exigence probatoire est très élevée. À cet égard, les réactions qu'une déclaration a suscitées lorsqu'elle a été faite sont d'une particulière pertinence afin de déterminer ses éventuels effets juridiques. Si le prétendu destinataire d'une promesse ne voit dans la déclaration rien qui vaille engagement juridique, prétendre le contraire a posteriori revient à rien moins qu'à une réécriture de l'histoire diplomatique. Deuxièmement, la Bolivie prétend pouvoir s'appuyer sur des documents rédigés unilatéralement par ses services, des documents purement internes, rapportant des phrases non vérifiées, non validées par les responsables chiliens à qui ces documents les attribuent. La Bolivie en fait grand cas, comme si elle pouvait s'appuyer sur ses propres documents internes pour asseoir sa démonstration de l'existence d'actes unilatéraux par lesquels le Chili aurait promis de concéder un accès souverain à la mer. Mais, Monsieur le Président, les phrases rapportées ont-elles été correctement retranscrites? Même à supposer que ce soit le cas, ont-elles été sorties de leur contexte? Le Chili ne saurait le dire, car les acteurs que ces textes mettent en scène ne sont pas là pour témoigner. La plus grande prudence s'impose donc. La Cour se rappellera d'ailleurs que lorsque la Cour permanente de justice internationale a donné foi à la célèbre déclaration Ilaine, elle s'est dûment assurée que cette déclaration correspondait, je cite, aux mots qui figurent dans la minute rédigée de la main de M. Ilaine. Fin de citation. Pour ce qui concerne les actes indubitablement attribuables au Chili, mes collègues reviendront sur chacun d'entre eux et démontreront qu'ils ne manifestent aucune intention de se lier juridiquement. Il me reste seulement à dire un mot, et c'est le troisième point sur lequel les parties divergent, le troisième point au moins sur lequel les parties divergent, des circonstances qu'il convient de prendre en considération pour déterminer la portée d'un acte. La plus déterminante est le contexte dans lequel l'acte intervient. Dans l'affaire Burkina-Mali, la Cour a analysé la portée d'une déclaration unilatérale du chef de l'État malien qui affirmait publiquement que, je cite, « Si la Commission de l'Organisation de l'Unité africaine décide objectivement que la ligne de frontière passe par Bamako, le gouvernement que je préside s'inclinera devant la décision. » Fin de citation. La Cour a constaté qu'il ne s'agissait pas d'un engagement juridique, non pas, comme le voudrait le professeur Acavant, parce que cette déclaration hyperbolique manquait de sérieux, mais parce qu'il suffit de lire ce que dit la Cour, et je la cite, « Rien ne s'opposait en l'espèce à ce que les parties manifestent leur intention de reconnaître le caractère obligatoire des conclusions de la commission de médiation de l'Organisation de l'Unité africaine par la voie normale, celle d'un accord formel fondé sur une condition de réciprocité. » Fin de citation. Ce sont très exactement les mêmes circonstances qui prévalent en la présente espèce. La Bolivie en appelle aussi à la règle de l'estoppel. Monsieur le Président, voilà encore une règle qui ne saurait être invoquée à la légère, à raison, pour reprendre les termes de la Cour dans l'affaire du Golfe du Maine, je cite, « des problèmes que peut poser en général l'application de cette notion en droit international ». Fin de citation. Ces conditions d'application sont par suite strictes et cumulatives. L'estoppel ne saurait jouer que dans les cas où il existe un doute sur la position de l'État à qui il est opposé, en ce sens qu'il y a une incertitude sur le point de savoir s'il a entendu se lier. C'est ce que le tribunal arbitral dans l'affaire des Chagos appelle la zone grise. En l'espèce, il n'existe aucun doute sur l'intention du Chili, qui n'a jamais été de se lier juridiquement, comme le Chili l'a clairement fait savoir à de nombreuses reprises. Pour le reste, les conditions de l'estoppel ont été résumées par votre Cour. Selon votre jurisprudence, l'estoppel suppose que l'État à qui il est opposé, je cite, ait adopté un comportement ou fait des déclarations qui auraient attesté d'une manière claire et constante qu'il avait accepté une obligation. Elle impliquerait en outre que l'État qui invoque l'estoppel, se fondant sur cette attitude, ait modifié sa position à son détriment ou ait subi un préjudice quelconque. Fin de citation. Pour qu'il y ait estoppel, il faut donc d'abord que le comportement ou les déclarations de l'État en cause aient attesté de manière claire et constante qu'il se tenait pour juridiquement lié. Ladite représentation ne saurait avoir un caractère incertain. En l'espèce, aucune représentation claire, constante et non équivoque n'a attesté que le Chili se tenait pour lié par l'obligation alléguée par la Bolivie. Les termes de certaines déclarations chiliennes ont reflété une ouverture à une négociation qui ne saurait être légitimement comprise comme autre chose que comme une fort classique posture diplomatique. L'estoppel supposerait aussi que la Bolivie apporte la preuve documentaire qu'elle s'est fondée en toute bonne foi sur la conduite chilienne pour croire à un engagement juridique de sa part. Il ne suffit pas, évidemment, pour la Bolivie de le dire à la barre. Il faut qu'elle le prouve. Or, non seulement la Bolivie n'apporte aucune preuve documentaire à cet égard, car il n'y a strictement rien dans son dossier qui aille en ce sens, mais surtout, elle ne le peut pas, puisqu'elle était parfaitement au courant de la position chilienne, à la fois du fait des termes soigneusement choisis par le Chili dans ses différentes communications officielles, qui ne laissent aucun doute sur ses intentions, mais aussi à la suite des dénégations chiliennes, par exemple celles de 1963, 1967, 1987 et 1988. La Cour mondiale a toujours rejeté la thèse de l'estoppel dans de telles circonstances. L'estoppel supposerait encore que la Bolivie apporte la preuve qu'alors qu'elle se serait fondée de bonne foi sur une apparence créée par la conduite du Chili, le prétendu changement de position de ce dernier lui aurait fait subir un dommage, mais là encore, le dossier bolivien est vide. J'en viens alors, Monsieur le Président, au contenu d'une obligation de négocier lorsqu'elle existe. Permettez-moi 2 remarques d'ordre général avant d'évoquer le cas d'espèce. Premièrement, la Bolivie fait fausse route en postulant que ce contenu répondrait à des standards généraux qui seraient toujours pertinents. Comme l'observait Paul Reuter, je le cite, « Il n'y a pas une obligation uniforme de négocier. » Fin de citation. Il faut donc, et ceci relève en réalité du bon sens, distinguer selon chaque cas. Deuxièmement, la Bolivie se fourvoie également en prétendant dans sa réplique qu'une obligation de négocier, lorsqu'elle existe, se définirait au regard de sa prétendue cause. En réalité, à l'image de toute obligation internationale, une obligation de négocier, lorsqu'elle existe, s'interprète au regard des termes de l'engagement pris, ainsi que de son objet, tel qu'il est révélé par ces termes. J'en viens alors aux faits, c'est-à-dire à l'objet de l'obligation de négocier dont la Bolivie se prévaut devant votre cour. Cet objet n'est pas, contrairement à ce que le professeur Forteau a soutenu mardi, en s'appuyant sur un document de 1975, je cite, « de parvenir à une solution définitive à l'enclavement de la Bolivie ». Fin de citation. L'objet de la négociation serait, si, comme on le doit, l'on s'en tient aux termes contenus dans les textes attribuables au Chili, desquels la Bolivie prétend tirer cette obligation, de chercher s'il existe une solution à l'aspiration bolivienne qui soit en même temps acceptable par le Chili au regard de ses propres intérêts. Elle serait de, en anglais, « reaching a mutually convenient solution », selon les termes du document de 1975 que mon contradicteur vous a présenté de manière biaisée. Il s'agirait de négocier ex nihilo sur la matière qui est l'objet des négociations, sans autre contrainte que celle de rechercher s'il est possible pour chaque partie de satisfaire ses propres intérêts tout en satisfaisant les intérêts de l'autre. Autrement dit, l'objet de cette négociation ne serait pas de concilier des droits concurrents revendiqués par le Chili et la Bolivie, car la Bolivie ne revendique aucun droit d'accès à la mer, comme vous l'avez jugé dans votre arrêt sur les exceptions préliminaires. Son objet ne serait pas davantage de mettre en œuvre un droit que la Bolivie et le Chili se seraient mutuellement concédés, car ils ne se sont rien concédé de tel. Il ne s'agirait pas non plus de mettre en œuvre une obligation de régler pacifiquement un différend. Comme je l'ai montré, il n'y a aucun différend dont la Bolivie puisse se prévaloir au titre de l'obligation de régler pacifiquement des différends qui ait fait naître une obligation de négocier. Dès lors, la jurisprudence relative à ces types de négociations, la seule qui soit invoquée par la Bolivie dans ses écritures et dans ses plaidoiries, ne lui est d'aucune aide, et c'est un pur contresens que de l'invoquer. Si l'obligation existait, il s'agirait donc, j'y insiste, d'une obligation de comportement qui consisterait pour le Chili et la Bolivie à confronter librement leurs points de vue afin de rechercher s'ils peuvent trouver un accord mutuellement acceptable tant qu'ils ont la conviction qu'une telle solution est envisageable. Le point important à souligner ici est qu'une telle obligation, lorsqu'elle existe, ne saurait survivre au constat de l'une ou l'autre des parties, ou des deux, qu'aucune solution mutuellement satisfaisante ne saurait être trouvée. Le professeur Forteau prétend l'inverse, soutenant qu'en droit international général, je cite, « l'obligation de négocier est une obligation continue », fin de citation, en se référant de manière énigmatique, dans la présente instance, à l'article 33 de la Charte des Nations Unies, et ce, apparemment sans s'être entendu avec le professeur Lowe. Mais peu importe. En toute hypothèse, le droit international général ne saurait être une source de l'obligation de négocier en cause dans la présente espèce. La Cour aura également pris note de la formule du professeur Forteau, indiquant que l'obligation de négocier ne saurait s'éteindre à raison du fait qu'elle aurait été pleinement exécutée, quand bien même les parties auraient fait des efforts de bonne foi pour chercher un compromis qu'elles n'ont pas trouvé, puisque cette hypothèse n'a pas été prévue par les engagements et déclarations du Chili. C'est une position très mystérieuse, mais peut-être que la Bolivie détaillera son propos à cet égard lundi. En tout état de cause, Monsieur le Président, l'engagement de négocier n'implique pas celui de s'entendre, avait déjà souligné la Cour permanente de justice internationale. Dès lors, s'agissant d'une négociation dont le seul objet est la recherche d'une solution mutuellement satisfaisante, Si une partie en vient à constater qu'aucune des solutions qui s'offrent à elle ne peut s'avérer satisfaisante, elle sera évidemment en droit de considérer que l'engagement de négocier qu'elle a initialement contracté, qu'elle aura exécuté autant que de raison, n'a plus d'objet. Il est à cet égard, là encore utile de se référer à Paul Reuter. Je cite : « Si le résultat des négociations ne peut être atteint que par un accord, par exemple dans le cas de négociations pour des échanges commerciaux, et si les perspectives de succès semblent définitivement écartées, il est raisonnable d'admettre que l'obligation de négocier est caduque faute d'objet. » Fin de citation. Monsieur le Président, Mesdames et Messieurs de la Cour, ces dernières considérations n'ont été présentées que pour surplus de droit. Elles ne valent qu'à propos d'une obligation de négocier dûment constatée. Mais en l'espèce, bien que la Bolivie en ait appelé à toutes les sources possibles du droit international, le chaînon manquant, l'obligation juridique, demeure manquant. Ceci conclut mon propos. Je vous remercie de votre bienveillante attention et vous prierai, Monsieur le Président, d'appeler à la barre Dr. Kate Bartlett.
I thank you, and I now call Dr. Kate Bartlett to take the floor.
Thank you. Mr. President, Madam Vice President, members of the Court, it's an honour to appear before you again today and a privilege to have been asked by the Republic of Chile to address diplomatic interactions between Chile and Bolivia in the early part of the 20th century. Earlier this week, you heard from Bolivia's council that during this period, Chile made a binding legal commitment to negotiate sovereign access. This was said to be established through express agreement, unilateral declarations, and estoppel. For good measure, Bolivia also argued that this period confirmed the existence of a historical bargain to negotiate on sovereign access, predating and surviving the 1904 peace treaty. Remarkably, Bolivia did not take you through a single document. Instead, its submissions were made by multiple and repeated assertions about the evidence, with an occasional reference to highly selective extracts. It's my task today to take you through the actual evidence. I start with a Bolivian proposal in 1910. At that time, the 1904 peace treaty between Bolivia and Chile had been in effect for 6 years, and its comprehensive settlement had been implemented by both of them. Chile had control over the coastal provinces of Tacna and Arica to the west of the complete boundary agreed with Bolivia, with definitive sovereignty over those two provinces to be decided in due course as between Chile and Peru. It was in that context that Bolivia made a proposal to both Chile and Peru on 22 April 1910. You find this at tab 16 of your folder. Bolivia asked whether the two states would receive suggestions and listen to propositions from Bolivia concerning the possibility of Bolivian sovereignty over coastal territory and a port. Bolivia also said that it would be ready to propose compensation if the discussions proceeded, confirming that its proposal was not made on the basis of any pre-existing and uncompleted bargain. Bolivia sent a further letter to Chile a week later, assuring Chile that when formulating its aspirations to a port, Bolivia will listen with absolute deference to the advice and opinion of Chile, and that if Chile deems it more appropriate to postpone the study of the matter, Bolivia would do so. Chile replied on 14 August 1910. It said that in view of the arrangements with Peru concerning Tacna and Arica, Chile was unable to discuss Arica with Bolivia. However, Chile expressed willingness to discuss other means to serve Bolivia's commercial interests, including advantages for Bolivian commerce in Chilean ports. Bolivia then responded on 29 August, expressing appreciation for Chile's goodwill. It said that it would submit a memorandum containing its wishes to facilitate Bolivian commerce in Chilean ports, but in the event, Bolivia made no proposals. These exchanges show that the two states were not operating on the basis of any pre-existing obligation, nor were they creating any legal obligation. Bolivia was merely asking Chile to listen to its proposals, including concerning compensation, with absolute deference to Chile. It's clear from these exchanges that Bolivia was not acting on the basis of an unfulfilled historical bargain, but was instead seeking to reach a new agreement. This week, Bolivia mentioned two other pieces of evidence from this decade, but neither assists it. Bolivia told you that President Montes insisted in 1913 on the right of Bolivia to have its own port. The evidence submitted by Bolivia, which I've included at tab 20 of your bundle, indicates that in April 1913, before being re-elected president of Bolivia, Mr. Montes gave a speech suggesting that Tacna and Arica should be incorporated into Bolivia, but that his position was not accepted by the Bolivian government. You also heard this week that Chile's foreign minister, Bello Correcido, said in a book published in 1919 that Chile considered Bolivia's aspiration to have a port of its own to be legitimate and respectable. In the same book, the former minister explained in unequivocal terms that during the negotiations for the 1904 peace treaty, Bolivia abandoned any aspiration to a port on the Pacific. So Daniel took you to that passage in opening this morning. Bello Correcido also suggested that a re-emerged aspiration might lead to future agreements based on sufficient and equitable compensation for Chile. This shows that there was no unfulfilled historical bargain, and it also indicates that no commitment had been made. Bolivia places great weight on a document dated 10 January 1920, recording minutes of a series of meetings between the Minister of Chile and the Minister of Foreign Affairs of Bolivia. Bolivia chooses to call this document the 1920 Act. Professor Ackervan majored on the minutes of these meetings this week without actually taking you to them. He told you that they are an agreement to negotiate sovereign access, that they contain binding unilateral declarations to end Bolivia's landlocked status, and that they created an estoppel and gave rise to Bolivia's legitimate expectations. These arguments are all untenable. You find the minutes at tab 21. Turning to page 323, you see that halfway down that page and over onto the next, Chile's minister set out 7 ideas that might become the bases for an agreement. As Bolivia mentioned, these had been proposed by Chile 4 months earlier, but Bolivia's position at the time was not to accept them because they were conditioned on Bolivia providing support to Chile in the plebiscite. That condition remained controversial. Nevertheless, Chile did put forward its 7 points in the meetings in January. Starting at the second last paragraph on page 323, you see point 1, the 1904 peace treaty was said to define the two states' political relations and to have put an end to all the questions deriving from the war. Point 3 notes that Bolivia's aspiration to its own port was replaced by the construction of the railway and Chile's other obligations under the 1904 peace treaty. Over the page, at point 4, we see that Chile is willing to seek that Bolivia acquire its own access to the sea in the north of Arica. And point 5, Chile accepts to initiate new negotiations directed at satisfying the aspiration of Bolivia, subject to the victory of Chile in the plebiscite. Point 6 suggests that an agreement would need to be reached to determine the exact area, confirming that these were preliminary ideas, and that agreement would also need to address compensation for Chile. And point 7 states, Bolivia would of course coordinate its diplomatic action with that of Chile and would agree to cooperate effectively to secure a favourable result for Chile in the plebiscite over the territory of Tacna and Arica. Bolivia has quoted selectively from these preliminary points, but the meetings did not end there. The records continue for another 7 pages. So, taking note of the purposes of cordiality and political rapprochement, Bolivia set out its own points, and then Chile responded, and there was some more back and forth. Bolivia's minister then said, and this is the final paragraph on page 337, he invited Chile to a calm examination of the facts so that it can be decided by agreement, an agreement favourable to Bolivia's wishes in return for fair compensation. So it is clear that the 2 states' representatives were discussing ideas, nothing more. And that is confirmed by the following paragraph on page 339. It reads, "The present declarations do not contain provisions that create rights or obligations for the states whose representatives make them." The Bolivian foreign minister then reiterated Bolivia's wish to acquire the port of Arica, which was inconsistent with what Chile had proposed in its point 4, that is, cession of a zone in the north of Arica. This paragraph confirms 2 points. First, it is conclusive evidence of an intention by the signatories of the 1920 minutes not to assume any legal obligation on behalf of their states. Second, it confirms that no agreement was reached on Chile's proposed ideas, as Bolivia concluded the meetings by putting to Chile a proposal inconsistent with what Chile had proposed. Bolivia has put forward various arguments seeking to avoid the obvious effect of this key paragraph, but none are persuasive. The 1920 minutes did not create or confirm any legal obligation. And it also follows that Bolivia's claims that points 4 and 5 of Chile's ideas were binding unilateral declarations and representations giving rise to an estoppel are both hopeless. On Tuesday, Bolivia put forward 2 additional arguments on the 1920 minutes. It argued that the reference to the 1920 minutes in the preambles to the 2 1950 notes confirmed their legal effect. Bolivia referred to the 1920 minutes in the introductory wording of its note as one of the important antecedentes in the original Spanish, that reveal a clear orientation in the international policy followed by the Chilean Republic, while Chile's note in turn referred to these antecedents. Bolivia translates antecedentes as precedents, but the more accurate translation is antecedents in the sense of background. That word does not convey any legal connotation in the sense of legal precedent. This does not assist Bolivia. Bolivia also referred you to a book published in 2004 by a Chilean historian, which says that Chile assumed a commitment under point 5 of its ideas set out in the minutes. It is apparent that this post hoc characterisation is of little assistance to the court, and in a passage that Bolivia did not take you to, the same author said that the 1920 minutes is not a treaty. It merely enumerates the bases for a future treaty and records the considerations put forward by Chile and Bolivia in that regard. Finally, Bolivia has sought to make a case on estoppel and legitimate expectations, arguing that in reliance on Chile's proposal, instead of repudiating the 1904 treaty, Bolivia supported Chile in the plebiscite in expectation of a sovereign access to the sea. No evidence was given as to this alleged support, while Bolivia's own contemporaneous documents suggest that, as events unfolded, Bolivia was not willing to cooperate with Chile in the then anticipated plebiscite. In any event, the plebiscite never took place, so Bolivia's case on reliance is puzzling at the very minimum. As to the assertion that it refrained from repudiating the 1904 peace treaty in reliance on Chile's alleged promises, in fact, Bolivia sought to do that very same year in a claim before the League of Nations. So in November 1920, Bolivia brought a claim to the League for revision or nullity of the 1904 peace treaty. Chile opposed that claim, and it was ultimately found to be beyond the competence of the League. In a statement before the Assembly of the League on 28 September 1921, Chile's delegates said, "Bolivia can seek satisfaction through the medium of direct negotiations of our own arranging. Chile has never closed that door to Bolivia, and I am in a position to state that nothing would please us better than to sit down with her and discuss the best means of facilitating her development. It is her friendship we desire." Counsel for Bolivia took you to that statement on Monday, but he referred only to the first sentence. It was only on the basis of this selective quotation that he could suggest it concerned sovereign access. On Tuesday, Counsel for Bolivia then told you that by this statement, Chile represented before the League of Nations that repudiation of the 1904 peace treaty was unnecessary because Bolivia can seek satisfaction through the medium of direct negotiations. This is again said to form the basis of a claim of estoppel and reliance on legitimate expectations. I have 3 points on this. First, and as I've explained by reference to the full quotation, Chile's statement was not a representation that Chile would negotiate sovereign access. Second, Bolivia did not then accept Chile's offer of discussions facilitating its development, but instead, 2 months later, Bolivia proposed to Chile that there be a tripartite arbitration on the question of the fate of Tacna and Arica, or that it be considered at an international conference. In response, Chile was clear that the dispute over Tacna and Arica did not involve Bolivia. It recalled that Bolivia had been invited to explain its points of view regarding the aspirations to have a port on the Pacific. But Bolivia responded that it did not have any proposals to make to Chile on the subject. None of this supports Bolivia's new case on reliance. Third, Bolivia has not suggested that there was some other course or sound legal basis as to which it intended to pursue a claim to repudiate the 1904 peace treaty and its definitive settlement of the two states' land boundaries. If Bolivia had a serious case on estoppel, there would have to be some actual evidence of that, but Bolivia has not taken you to anything. I move forward in time another 2 years to correspondence in early 1923. Bolivia again asked Chile to revise the 1904 peace treaty, and on 6 February 1923, Chile refused, but it stated that it maintains its purpose to listen with the utmost spirit of conciliation and equity to the proposals that Your Excellency's government wishes to submit in order to celebrate a new pact regarding Bolivia's situation, but without modifying the peace treaty and without interrupting the continuity of the Chilean territory. Chile confirmed that this expression of openness to listen to Bolivia was not made on the basis of any unfulfilled historical bargain, because it explicitly noted that any discussion would be on the basis of mutual compensation, a crucial detail which Bolivia did not mention when it referred to this document earlier this week. In any event, Chile's willingness to listen to Bolivia's proposals does not demonstrate an intention to create a legal obligation. Bolivia took you to its internal report of a meeting said to have taken place the next day between its ambassador in Santiago and Chile's foreign minister. Bolivia's counsel placed particular emphasis on this. It was one of only the 3 pieces of evidence he showed you. But the document itself records, "The minister invited me to a meeting today. He said it was useless for Bolivia to insist on the revision. When the situation of Tacna Arica is resolved, we will be able to give a port to Bolivia in return through compensations." This was said to carry all the effects of a binding unilateral declaration. It was projected on the screen as a quotation of the words of Chile's foreign minister. You were not told that this is a paraphrased account found in a summary internal Bolivian record of a meeting. The document then continues, "I replied that I would request for instructions and told him that Bolivia hopes that its current negotiations reach a defined result." But when Bolivia replied to Chile's letter of 6 February, it asked Chile again to revise the 1904 peace treaty and said that absent agreement on this, it would end the negotiations. This was unacceptable to Chile, and any discussions were brought to an end, consistently with Bolivia's expressed intention. In the first round, Bolivia also placed significant emphasis on the words of President Arturo Alexandri, said to be spoken a week later, on 27 February 1923. But again, the alleged statement is paraphrased, not quoted, in a summary internal Bolivian document. We do have an actual quote of President Alexandri just 6 weeks later, in which he said that he would consider Bolivia's aspirations, but that Chile had no legal commitment with Bolivia. You find the evidence of this quote at tab 28. Referring to the pending arbitration with Peru over Tacna and Arica, the President said, "If the arbitral award so provides, I will generously consider Bolivia's aspirations in the manner and under the terms that were set out in the February letters. This will be the new and valuable contribution of my country to the harmony of America, since legally we have no commitment towards Bolivia. We have had our relations completely and definitively settled by the 1904 treaty." Bolivia then moves forward another 3 years to documents following a proposal made to Chile and Peru in late 1926 by the United States Secretary of State, Kellogg. In the context of the dispute between Chile and Peru, Kellogg's proposal was that those 2 states agree to cede sovereignty over all of Tacna and Arica to Bolivia in exchange for adequate compensation. Chile responded to the proposal in a document addressed to the US Secretary of State, the so-called Mate Memorandum. The relevant parts are at tab 30 on pages 436 and 437. You see there that Chile said that it has not rejected the idea of granting a strip of territory and a port to the Bolivian nation, and that once the question of definitive sovereignty over Tacna and Arica had been determined, it would honour its declarations in regard to the consideration of Bolivia's aspirations. But it also noted that the Kellogg proposal goes much further than the concessions which the Chilean government has generously been able to make. It was explicit that it has always been disposed to listen to all propositions for settlement, including for compensation, but in discussing such propositions, it was not abandoning its rights to have the dispute with Peru over Tacna and Arica resolved in accordance with the Treaty of Ancon. It said it would consider in principle the proposal, nothing more. 3 days later, Bolivia sent a letter to Chile referring to and purporting to accept the Mate Memorandum. Apart from the fact that the memorandum was not addressed to Bolivia, it will be apparent to the court that statements to the effect that a state has not rejected a particular course of action and that it will consider a proposal and another country's aspirations does not suffice to establish a legally binding obligation to negotiate. The Kellogg proposal was ultimately not accepted by either Peru or Chile. Bolivia acknowledged that in a lengthy circular issued to its legations abroad in January 1927, but it did not then assert that Chile was nevertheless obliged to negotiate with it on the basis of a unilateral promise in the Mate Memorandum or an agreement established by that document and Bolivia's response to it, or indeed on any other historical basis. Following these few diplomatic communications in 1926, there was an extended period of silence on Bolivia's part. In 1929, through the Treaty of Lima, Chile returned the province of Tacna to Peru and obtained definitive sovereignty over the province of Arica. As the court is aware, the supplementary protocol to the Treaty of Lima provided in its Article 1 that neither Chile nor Peru would cede either Tacna or Arica to a third state without previous agreement between them. Bolivia reacted to that provision at the time by asserting that this policy is not one of real international cooperation and is capable of producing profound resentment in Bolivian consciousness. It did not react by claiming that Chile was subject to an obligation to negotiate. Instead, there was silence on the subject of Bolivia's aspiration for sovereign access to the sea that lasted well into the 1940s. Mr. President, members of the court, Bolivia's emphasis on this period of history is perplexing. Chile did not create or confirm any legal obligation to negotiate on sovereign access, and the weakness of Bolivia's claim to the contrary is so apparent that one wonders why Bolivia has troubled the court with this period. And the fact that Bolivia now pleads its case on estoppel, primarily by reference to alleged representations that are nearly a century old, and without any meaningful effort to show reliance, suggests that that is not a serious case at all. Bolivia's emphasis on this period seems to be an attempt to find support for Bolivia's new theory of continuity. But what the actual evidence from this period shows is that Bolivia was seeking from 1910 to reach a new agreement, to vary what had been agreed in 1904. It was not asserting the existence, as Bolivia's council now do before you, of some sort of historical understanding that survived from the 19th century, to which effect remained to be given. The record also shows that the interaction between the two states in this period did not create any obligation to negotiate sovereign access, and Bolivia's attempts to claim otherwise do not find support in the actual evidence. Mr. President, that concludes my submissions, and I ask that you call Mr. Wordsworth to address you on the 1950 diplomatic notes.
I thank you, and I now invite Mr. Wordsworth to take the floor. You have the floor.
Mr. President, members of the court, it's a privilege to appear before you and to have been asked by Chile to address one of the mainstays of Bolivia's case, that its case on international agreements said to have been generated by the two diplomatic notes of 1st and 20th June 1950 and by the joint declaration of Chirania of 8th February 1975. I start with the notes of 1st and 20th June 1950. And looking at the court's two well-known cases on formation of an international agreement, there is a form of reality check that it may be helpful to have in mind. In the GNC, the joint communiqué at the heart of the case was dated 31st May 1975. This was invoked by Greece in proceedings commenced on 10th August 1976. In Qatar and Bahrain, the minutes at issue had been signed in December 1990, and this document was invoked in proceedings instituted by Qatar on 8th July 1991. And here, the June 1950 notes are dated some 63 years prior to the commencement of the proceedings in 2013. following decade after decade in which there was no negotiation to Bolivia's satisfaction on sovereign access to the sea, and where the one extended negotiation on this topic, the Chiraña episode of the mid-1970s, ended with Bolivia breaking off diplomatic relations. And as I'll explain in a little more detail later, it is not as if during that 63-year period, Bolivia sought to maintain a consistent position that the notes were legally binding. So this is strongly suggestive of the absence of any legal obligation. I turn then to the language of the two notes. First, Bolivia's note of 1st June 1950 at tab 32 of your folder. A proposal is made with such important antecedents that reveal a clear orientation in the international policy followed by the Chilean Republic. I have the honor of proposing to Your Excellency that the governments of Bolivia and Chile formally enter into a direct negotiation to satisfy the fundamental need of Bolivia to obtain its own sovereign access to the Pacific Ocean, thus solving the problem of the landlocked situation of Bolivia on bases that take into account the mutual benefits and genuine interests of both peoples. 3 short points as to this proposal. First, there is the reference to the important antecedents. That is, a reference to various past statements made by Chilean representatives and other materials. There's no suggestion here that those established any binding legal commitment, and nor could there sensibly be so. Nor does the characterization of them as antecedents somehow suggest that they are legally binding, as Dr. Parlett has already just mentioned. Secondly, the proposal is to enter formally into a direct negotiation, una negociación directa. This is not a proposal to agree to an entirely open-ended obligation to negotiate. It is a proposal to enter formally into a negotiation and nothing more. And I recall Professor Tuvenau's remarks on entry into a negotiation that were made just before the break. Thirdly, Bolivia's proposal is for a direct negotiation with a precisely defined object of satisfaction to Bolivia, to satisfy the fundamental need of Bolivia to obtain its own sovereign access. When on 20th June 1950, Chile responded to Bolivia's note, it departed in material respects from what had been proposed. The note, at tab 33 of your folder, recalls what Bolivia has said about the orientation in Chile's international policy and quotes Bolivia's proposal. Chile then explained, from the quotes contained in the note, I answer, it flows that the government of Chile, together with safeguarding the de jure situation established in the Treaty of Peace of 1904, has been willing to study, through direct efforts with Bolivia, the possibility of satisfying the aspirations of the government of Your Excellency and the interests of Chile. Again, there's no suggestion here of any extant legal obligation. Further, and this is a point I'm going to return to a little later, Chile wished to emphasize its policy with respect to safeguarding the legal position established by the 1904 peace treaty. Chile then said, at the present opportunity, I have the honor of expressing to Your Excellency that my government will be consistent with that position and that, motivated by a fraternal spirit of friendship towards Bolivia, is open, formally, to enter into a direct negotiation aimed at searching for a formula that would make it possible to give Bolivia its own sovereign access to the Pacific Ocean and for Chile to obtain compensation of a non-territorial character which effectively takes into account its interests. 6 points here. First, Chile was stating that it would be consistent with its prior position, that is, of being willing to study through direct efforts with Bolivia the possibility of satisfying its aspirations. There's no hint in that language of any past or newly informed intention to be legally bound, and likewise no hint that Chile was acting by reference to the Bolivian rights that are now alleged to exist pursuant to the so-called historical bargain. Secondly, Chile did not say it was agreeing to anything. As to the term used, Chile said it is open to, está llano a, which does not suggest acceptance of any legal obligation. To take an example of where Bolivia itself has used this formulation, in May 1962, after it had broken off diplomatic relations with Chile because of disagreement over the river Lauca, Bolivia stated as follows to the OAS: "The government of Bolivia, in this respect, declares that it is open to, está llano a, resume its relations with the government of Chile." In precisely the same way as Chile's 1950 note, the term está llano a is being used here to convey a statement of political willingness, not the undertaking of a legal obligation. My third point: what Chile was open to in its note was formally to enter into a direct negotiation, that is, a discrete event, not an open-ended obligation to negotiate. Fourthly, as to the subject matter of the negotiation, this was not what Bolivia had been seeking. Bolivia sought negotiation to satisfy the fundamental need of Bolivia to obtain its own sovereign access. Instead, Chile was open to a negotiation aimed at searching for, that is, aimed towards a form of conduct, searching for. Then what is being searched for is a formula, another notably vague concept, that would make it possible for Chile, that is, to give Bolivia its own sovereign access. Wording that reinforces how far removed this is from the more usual situation of a negotiation where competing rights are being asserted. On Tuesday, Professor Ramiro Bretons quoted from the note, saying that Chile was open formally to enter into a direct negotiation, and he said that l'objectif est parfaitement indiqué, to give Bolivia its own sovereign access to the Pacific Ocean. And that, of course, is to skip over the key words in the middle. And on that basis, to suggest quite incorrectly that Chile was open to a negotiation with the same object that had been proposed by Bolivia. Quite plainly, it was not. And one wonders if the submission could have been made if you'd been taken to the actual document. And pausing here, it's useful to see how different the actual wording is from cases that have come before this court concerning a genuine treaty obligation to negotiate. In the interim accord case, the treaty provision at issue, Article 5.1, stated, "The parties agree to continue negotiations under the auspices of the Secretary-General of the UN, pursuant to Security Council Resolution 845, with a view to reaching agreement on the difference described in that resolution," and in Resolution 817. So, clear words of agreement with respect to the continuance of negotiations, and a mutually agreed object. To similar effect, as the court will recall, Article 6 of the Nuclear Non-Proliferation Treaty provides each of the parties to the treaty undertakes to pursue negotiations in good faith on effective measures relating to cessation of the nuclear arms race at an early date and to nuclear disarmament, and so on. And such language, where states have indeed sought to generate a legal and ongoing obligation to negotiate, could scarcely be more different from what is now before the court. And this leads to a fifth point. Bolivia had in its note proposed a negotiation on one basis. You can see on the screen. While Chile stated that it was open formally to a negotiation with respect to something materially different. And one could conceive of a situation where Bolivia subsequently agreed to the different negotiation that Chile was open to, but that is not what happened. On Tuesday, Professor Ramiro Bretons emphasized that Chile had had Bolivia's note in draft since June 1948, that Bolivia had seen Chile's note in draft on 9th June 1950, and that an amendment to Chile's note was made on Bolivia's suggestion. But that background doesn't help Bolivia at all. To the contrary, if Chile had wished to align its wording with that of Bolivia, it had more than ample time and opportunity to do so, and it plainly elected not to. The degree of stage managing reflects the intense political sensitivity and the desire that statements made would be in a form acceptable to a wider audience in each state. It does not somehow convert two carefully drafted but materially different statements of position into an international agreement. And this leads to my sixth and final point on the wording of Chile's note of 20th June. The negotiation, as proposed by Bolivia, said nothing about compensation to Chile, but referred, with no doubt deliberate vagueness, to solving the problem of the landlocked situation of Bolivia on bases that take into account the mutual benefits and genuine interests of both peoples. By contrast, the negotiation to which Chile expressed its openness included for Chile to obtain compensation of a non-territorial character which effectively takes into account its interests. This is another element of important difference between the two notes, and compensation to Chile is also a notable absentee so far as concerns the relief that Bolivia is seeking before this court. You're told that the 1950 notes make up a treaty. You're asked to give effect to that treaty, and yet the relief sought bears no resemblance whatsoever to what Chile in fact declared itself open to on 20th June 1950. And it even goes so far as to leave out altogether the key matter of compensation. And that is not a coherent legal position. On Bolivia's case, compensation should be one unavoidable aspect of a central treaty-based quid pro quo that it now seeks to enforce. Yet, you are asked to order negotiations that refer to only one part of the allegedly agreed package. And so one wonders what is motivating this obvious inconsistency in Bolivia's case. And in answering that question, I wish to move to the second area of inquiry identified in the court's jurisprudence on formation of an international agreement, the particular circumstances in which the notes were drawn up. 3 points. First, Bolivia wishes the court to focus on statements made by Chile in 1948. In particular, Bolivia's counsel wished you to believe that a binding verbal commitment to negotiate was given by Chile's President González Videla at a meeting of 23rd July 1948, or at least that a statement was made on which it could legitimately rely. This is the statement, what has been verbally agreed is as if it had already been written, which is contained in a Bolivian internal report that covers the meeting. and Chile has been unable to locate any record of this meeting, but I think that matters little. You were not taken to the statement of President González Videla of 1st June 1948, setting the framework for the discussions of June-July 1948. You see there that Bolivia's ambassador, Austria Gutierrez, requested authorization to declare open negotiations aimed at satisfying the Bolivian port aspirations. Chile's president refused, and you can see that from the next two paragraphs, where he's saying that Bolivia must first come up with a concrete and precise proposal. And then again, over leaf, the president added that under no circumstance could these informal talks be relied on as basis for any discussion, since the very idea of granting a strip of land north of Arica had merely been the subject of a conversation, and the president may not take initiatives on a problem that concerns Bolivia, not Chile. So, informal talks that could not be relied on. And in the event, it is plain that Bolivia was not relying on anything that had been said in these talks. In an internal communication of 25th May 1950, Bolivia's ambassador described what Bolivia was seeking to achieve through its submission of what was to become the note of 1st June 1950. He said, "The submission of this note, a copy of which I am enclosing, was agreed to with the Undersecretary of Foreign Affairs, Mr. Manuel Trucco, and has the aim of taking the port negotiation out of the field of mere personal talks, which could be prolonged indefinitely, as has already happened since August 1946, to formalize and document it." There is no trace here of a belief that any binding commitment had been made by Chile, and no hint of any reliance by Bolivia on anything that had been previously said. What is more, what was to become Bolivia's note of 1st June 1950, the aim was to formalize and document the entry into a negotiation, not to establish a binding agreement to negotiate. This brings me to my second point. You can also see from this document of 25th May 1950 that Bolivia's ambassador was hopeful that Chile would conclude an exchange of notes that week. He said, and the emphasis is in the original, "If this were to happen and we managed to conclude the exchange of the said notes, we would be taking a particularly transcendental step, even if it would only probably be in the general terms of the negotiation, namely to acknowledge the fundamental need of Bolivia to obtain its own and sovereign access to the Pacific Ocean." Bolivia's ambassador was not saying, if the exchange takes place, we will have a treaty or some other form of legally binding commitment from Chile to negotiate. There is simply no suggestion of that. He saw that it would be a politically, not legally important step in terms of securing a particular express acknowledgement of Bolivia's need, which was not, however, forthcoming in Chile's note. My third point concerns compensation, and with your leave, Mr. President, if I could just complete this point, it'll lead to a natural breaking point. By March 1950, Chile had decided that this should be in the form of access to Bolivian waters. At a meeting of 14th March 1950, Bolivia's ambassador recorded that President González Videla of Chile mentioned for the first time the possibility of irrigating the north of Chile with Bolivian waters, which in his view would cause the arrangement to yield economic benefits for Chile. Only if the Chilean people see there is some compensation for the territory ceded will the arrangement be accepted. And this is the Bolivian ambassador's record of what the Chilean president is saying. "I would submit to the Chilean public opinion a simple formula, exchanging land for water. Thus, the northern part of the country would not resist the decision but support it in favor of Bolivia. Indeed, a matter so significant as territorial cession could scarcely be agreed to without popular support, including the support of those most closely affected. The hydro project was then raised by President González Videla in discussions with US President Truman in April 1950. As Chile's president was recorded as explaining to Bolivia's representative in Washington, Chile will not ask for territorial or economic compensation. Therefore, it will merely seek an agreement allowing it to use the waters of the river Desaguadero for purposes of irrigation and production of electrical energy, which he, that is Chile's president, hopes will be useful for the two countries and will also serve to justify to the Chilean public opinion the agreement that could be reached to give Bolivia a port of its own to the north of Arica. The note continues, and you can also see our sketch map putting before you the rough locations. President Truman was very pleased with the project being considered by the governments of Bolivia and Chile and offered to provide the firm and determined support of the US government. Now, this matters for two reasons. First, it shows again how incorrect it is for Bolivia to contend that Chile was willing to agree to a sovereign access to the sea by reference to some historical bargain. Chile was only open to a negotiation on the basis of compensation. Indeed, the Chilean government did not have a free hand. It had, in the Chilean president's words, to justify to the Chilean public opinion the agreement that could be reached to give Bolivia a port of its own to the north of Arica. Secondly, to enter into a negotiation was an extraordinarily sensitive matter. In the event, there was a strong adverse reaction to the prospect of a negotiation in both Chile and Bolivia, and the 1950 negotiation never took place. You heard remarkably little of that earlier this week, because Bolivia would rather put before you idealized images of two states walking together on a path of reconciliation. But in Chile, there was a powerful reaction against the prospect of negotiating a cession of territory, while in Bolivia, there was a similar adverse reaction because of the fear that Bolivia would be negotiating with regard to its waters. And so far as concerns the current issue of formation of an international agreement or other binding obligation, given the huge political sensitivity of which all the protagonists were more than fully aware, as one sees from the pre-June 1950 documents, the point is that it is objectively unlikely that either Chile or Bolivia would have been willing to bind themselves to negotiate. Mr. President, members of the court, I think I have overrun a little. I apologize for that. With your leave tomorrow morning, I will move on to the events subsequent to the June 1950 notes.
I thank you. This brings us to the end of today's oral proceedings. The court will meet again tomorrow, Friday, 23 March at 10 a.m. to hear the second part of Chile's first round of oral argument and to allow Mr. Wordsworth to finish his speech. The sitting is adjourned.